Right, so we are going to begin in this minute. Okay. Welcome, ladies and gentlemen. Namaste, assalamu alaikum. This is the 109th edition of our Zoom public meeting for 108 unbroken continuous weeks. We have been here every single Sunday. In the past 2 years, 3 months, and 1 week, we have featured over 353 presenters from all parts of the world speaking on 108 topics. We wish to sincerely thank all those who have contributed in whatever way to the success of this ongoing pan-Indo-Caribbean and pan-Indian diaspora project. Our chairperson today / tonight is Charlene Maharaj, who is no stranger to this platform. She has enjoyed 22 years in the airline, aviation, tourism, and marketing industry. Charlene, welcome and please share the meeting. Unmute. Oh, Ravin, you have to unmute, yeah?
Should be able to unmute.
Thank you very much. Thank you, Kumar, for that warm welcome. I may not always be able to be here, but it is certainly always my pleasure. Good night, good morning, and good evening. Namaste and assalamu alaikum, ladies and gentlemen, brothers and sisters, and special welcome to our guest speakers. Indo-Caribbean Cultural Center thanks you for taking time to join us from whichever part of the globe you might be this evening or this afternoon. We would also like to express our gratitude to all those persons who have registered for our ICC one-week cultural tour in TNT, which is being hosted between August the 4th to the 11th this year. It will certainly be an exciting opportunity to take this virtual platform to the physical world and spend time with each other on a social level, and if I may dare say so, a more human level. Ladies and gentlemen, this is a weekly forum being hosted by the Indo-Caribbean Cultural Center, a legally registered research and publishing company operating since 2010. In order to continue this weekly program and to make it bigger and better, we are asking you to give us your suggestions. We also welcome donations. Please contact Dr. Mohabir for details. Before we begin our discussions today, however, Indo-Caribbean Cultural Center, on behalf of all its members and organizers, categorically condemns in the strongest manner the rampaging mobs who invaded the Monrepo market in Guyana, beating and robbing Indian vendors, burning their vehicles, and yes, looting their goods. We also condemn the silence around these events, especially in light of CARICOM meetings currently being held. We urge persons who are with us today to state your names in the chat and join us in publicly condemning these violent acts against our Caribbean brothers and sisters. Simply state your name and say you condemn the violence in Guyana. We shall take this list and publish it in our online newspaper. We also hereby call on the Guyana government to charge the members of this armed and errant mob, highlight it internationally, and take the necessary steps to protect these citizens from any further retaliation. We also urge the government to go one step further to adequately compensate victims for their loss and the trauma they suffered. In close proximity to this call, however, is today's topic. It's an urgent and a critical one. It is about justice after all, justice in our land. Who gets it? How and where do we find that justice? Ladies and gentlemen, our moderator this evening is Ms. Shalima Mohammed. Shalima is a co-director of this Zoom platform. She is also a business teacher and a researcher from Trinidad and Tobago. She obtained her master's degree in business psychology from Franklin University in the USA. Shalima, over to you.
Thank you so much. Assalamu alaikum, everyone. Namaste, and a very, very warm welcome to all of you from a very hot and sunny Trinidad and Tobago. Ladies and gentlemen, like most of the others, this public meeting will take the form of a panel discussion. So I'll ask you to kindly mute your microphone unless you are asked to speak. The microphone icon is at the lower left corner of your screen. The background noise can be distracting, so let's please try to avoid that. This meeting should just be about 2 hours. And today we are talking about the Caribbean Court of Justice versus the Privy Council implications for the Indian diaspora. In order to get everyone into this meeting, we generally circulate invitations. And upon my circulation of an invitation this morning, I received a comment from a friend of mine. So I'll just read that to you. He says, my cousins who is in the legal fraternity, this is in Trinidad and Tobago, told me that if we go with the Caribbean Court of Justice, Caribbean people might never, in bold print, never get justice. The Caribbean is too small an environment, and perpetrators, if they are affluent enough, can influence the outcome of a trial. Conversely, the Privy Council absolutely does not give a damn who you are, but they are going to judge according to the law. This is a private comment, but there's merit to it. And I'll ask Ravin now to play a video that is of Senator Anil Roberts from our local Senate. And this is a meeting that took place only recently. Ravin, can you bring that up, please?
Thank you, Madam President. It's indeed a pleasure. Thank you, Madam President. I see there's a lot of screams over there. But if we look back, when we're speaking about politics and political interference, is it a mere coincidence that in our history of a two-party system, that the people who have been brought before the Court of Appeal who were politicians or politically aligned and were charged and brought forward and eventually freed by
Senator Roberts, you are casting aspersions on the administration of justice, and I will ask you, please remember I have spoken to you about the standing order, okay?
And I would just say that the following people who were unfortunate enough to go through our court system here, but were vindicated by the Privy Council include Satnarayan Sharma, Bastio Pandey, Finbar Ganga, Brian Kwaitong, Danraj Singh, Vijay Naran Singh, Tim Gopi Singh, and Ish Galbaran Singh. I cannot sing because I got thrown out of the choir, but that leaves it right there to be said. All of these were UNC, most East Indian, all vindicated
Madam
by
President,
the
Madam President.
No, it's fine. Senator Roberts, you are going down a road that you, no. And please, this is my final warning to you. I cannot warn you any further because I've been doing it too often. So I will ask you, please desist from this line that this course that you're pursuing. Please.
Madam President, while I hear you, the course that we are debating here, and we are discussing a very serious matter, it's whether we are going to believe in the culture and feel that all citizens will be confident in the CCJ being the final court of appeal, or whether the Privy Council provides some of the citizenry with added comfort about the possibility of impartiality in the judicial system. And I put it to you here that all of these people were vindicated by the Privy Council, and therefore they would feel comfortable that the Privy Council is able to hear arguments, hear legal arguments, take facts, and come to an impartial decision, and therefore the Privy Council should be maintained so that all the people in Trinidad and Tobago can feel secure. This is a debate. This is not here. This is not politics. This is not an emotion. It's just not simple red and yellow. It's a debate. I am providing facts. I am providing a different side that some others may not see because, as you know, our eyes and ears are always colored by our politics. So some may not see. So if you listen now, you can hear the other side, the other half, and maybe you may change your desire and your decision. That's what a debate is about. Senator Vera stated that there's no history or evidence of political interference in our judicial system. I wish that was so, sir, but I just told you some, right? I wish you were right.
Ravin, you have to end it.
Thank you, Ravin.
So we move on.
Thank you so much, Ravin. So I think Senator Roberts has adequately contextualized our position in Trinidad and Tobago. And so we will now hear from our esteemed speakers about this matter. Ladies and gentlemen, I want to introduce, first of all, Attorney Dr. Derek O'Brien. He's from the UK. He's a reader in public law at Oxford Brookes University, focusing on politics, history, and constitutional law in the Commonwealth Caribbean. Go ahead, please, sir.
Thank you very much, and thank you to Dr. Mahabir for inviting me to take part in this panel. I've been thinking about and writing about the Caribbean Court of Justice for almost 2 decades now, so it's lovely to get a chance to talk about it with a Caribbean audience. If I could have the first slide. Yes, and then if we could move on to the next slide. Yeah, I thought I would begin just by talking about the origins of the Caribbean Court of Justice. The Privy Council, of course, has been going since 1833, so it was established in that year, coincidentally the same year that slavery was abolished, to act as the final court of appeal for British colonies. So it heard appeals from British colonies right up until the point of independence, at which time it would have been open to independent countries to decide whether or not they wanted to continue to retain appeals to the Privy Council or establish their own final court of appeal. The first suggestion or the first idea of having a regional Court of Appeal was first suggested at the Caribbean Heads of Government Conference in 1970, and it was actually a suggestion by the Jamaican delegation at that conference. But nothing came of that suggestion. However, the idea really began to gain momentum as a result of the report of the West Indian Commission, their report, Time for Action. The West Indian Commission was chaired by Sir Sonny Ramphal, and he had this to say about having a regional court. He said, "The case for a court with both a general appellate jurisdiction and an original regional one is now overwhelming. Indeed, it is fundamental to the process of integration itself." So the West Indian Commission saw having a regional court as a very important part of enhancing regional integration, both economically and socially. And this is where I think where the idea came for having a court with a dual jurisdiction. So when we talk about the Caribbean Court of Justice's original jurisdiction, we're talking about its role in mediating disputes between the member states of CARICOM. And that's quite different from its appellate jurisdiction, which concerns civil and criminal and constitutional matters. So the idea is mooted by the West Indian Commission in 1992. It was, however, a further 13 years before the Caribbean Court of Justice actually opened its doors for business in 2005. So if I could have the next slide, please. I think what's most remarkable about the court's appellate jurisdiction is It's now 17 years since the court was first inaugurated, and yet there's still only 4 countries in the region that subscribe to its appellate jurisdiction. Guyana and Barbados signed up immediately, so back in 2005. In any event, Guyana had abolished appeals to the Privy Council back in 1970, so it had its own final appellate court. Guyana and Barbados were followed in 2010 by Belize, and then most recently by Dominica in 2015. So that causes us to ask, why haven't other countries in the region been willing to ratify or subscribe to its appellate jurisdiction? And we got some suggestion of why from the video that you played right at the beginning of this discussion. But what I'd like to do is just rehearse some of the arguments for and against abolishing the right of appeal to the Privy Council and instead replacing it with appeals to the CCJ. So if I could have the next slide. Okay, there are many arguments. I'm going to, for reasons of time and space, I'm just going to focus on 3 of the main arguments for replacing the Privy Council with the CCJ. The first is this idea of completing the circle of independence. So for countries like Jamaica and Trinidad and Tobago, signing up to the CCJ would complete the circle of independence that began in 1962. It's argued that vesting ultimate legal sovereignty in a foreign court 4,000 miles away and composed almost exclusively of foreign judges who have very, very little knowledge of the Caribbean is completely inconsistent with independence. And that's confirmed in that quote from Sir David Simmons, where he says, the independence of the state of the region will not be complete when our constitutions entrench as a foreign tribunal as our final court of appeal. It is inconsistent with independence. It's an affront to sovereignty and the sovereignty of independent nations. So that's the first argument. The second argument is accessibility. I've mentioned already that the Privy Council sits in Downing Street in London. It's 4,000 miles away. It has occasionally sat as an itinerant court, so it sat in the Bahamas in 2006, 2007, and 2009. And it also has at least once heard a case via teleconferencing, so via Zoom, but only one case so far. It is argued that it will be much more convenient, much quicker for litigants to be able to go to the Caribbean Court of Justice, the seat of the Caribbean Court of Justice in the Port of Spain. So quicker and cheaper, and therefore will improve access to justice. The third main argument is the idea, so it goes back to the idea that the Privy Council is composed of foreign judges with little or no knowledge of the Caribbean. It would be replaced by a regional court composed almost entirely of judges from the region, and it would empower those judges to give effect to regional standards and values. And there you have the quote from Justice Della Bastide, the former CJ of Trinidad and Tobago and the first president of the Caribbean Court of Justice. Okay, so those are the arguments for. If we could move to the next slide, we can look at the arguments against. So the first one is cost. The Privy Council is free. It comes at no cost to the countries that ratify its jurisdiction, its appellate jurisdiction. However, you have to set against that argument that all the countries originally signed up to the CCJ's appellate jurisdiction. So when it was established, all the countries in the region apart from the Bahamas, agreed to contribute to a trust fund of $100 million for the maintenance and running costs of the CCJ. So whether or not countries use the Privy Council as their final court of appeal, they're still paying towards that trust fund for the maintenance of the CCJ. The second argument is the caliber of the judges of the Privy Council. And it's true that the justices of the Privy Council are the same 12 justices that sit in the UK's Supreme Court. So they have a global reputation for excellence. The third is this idea of judicial independence that was hinted at in the video we watched from the Senate in Trinidad at the beginning. And this is the idea that local Caribbean politicians will somehow be able to influence the judges of the CCJ. And it's true, I've given you there a quote from Selwyn Ryan, who's written extensively about the degree of political interference with national judiciaries. Whether that is true also of the CCJ, I would say is highly contestable. That those who set up the CCJ were well aware of this problem, and they did everything within their powers to safeguard the independence of the judges by setting up an independent regional Judicial and Legal Services Commission that decide who gets appointed to the CCJ. So local politicians have no say in the appointment of the judges of the CCJ, with the exception of the president. And they also have no power to remove the justices of the CCJ. And then the final argument, though, I don't know now if this is just a historic argument, it was the idea that local politicians were keen to establish a regional court of justice because they wanted a hanging court. It's perhaps an unfortunate coincidence that the report of the West Indian Commission recommending establishing a regional court of appeal coincided with the decision of the Privy Council in Pratt and Morgan that it was unconstitutional to hang a man 5 years after his sentence for execution had been read out. And there was appeared to be a feeling locally that the judges of the Privy Council had overreached themselves and that they were interfering with a matter that was very much a matter for local politicians to decide. Okay, could I have the next slide? So I just want to go back to a couple of the points I made. That one, the idea that the Privy Council can develop a distinctively Caribbean jurisprudence, and the other against that is saying that it'll simply be a hanging court. And I want to use a couple of cases to illustrate why this argument is probably overly simplistic. But both of these cases concern the mandatory death penalty, which is so death is the mandatory sentence if a prisoner is convicted of murder. And it is agreed by the judges of the Privy Council and by judges internationally that having a mandatory death penalty is a cruel and unusual punishment, because it takes no account of the sentences of the crime, the circumstances of the crime or the circumstances of the offender. So it's completely arbitrary. No matter how heinous the particular crime, the sentence is always death. Now, despite the fact that mandatory death penalties violate international human rights norms, it has been very difficult in the Caribbean to have those laws that prescribe mandatory death penalty declared unconstitutional. That is because Caribbean constitutions, with the exception of Belize, contain these saving laws clauses. So these clauses immunize laws and forms of punishment that were lawful at the time that the Constitution came into effect. So these laws cannot be constitutionally challenged on the grounds that they violate any of the rights and freedoms guaranteed by those constitutions. And there's been an argument raging about this ever since the beginning of the century. And I want to just look at a couple of cases where these were considered. The first is a decision of the Caribbean Court of Justice in the case of Nervais. And
Dr.
that was
O'Brien, excuse me.
Yeah.
Would you mind wrapping up in 2 minutes, please?
Yeah, I'm nearly there. So in Nervais, it was on appeal from the Court of Appeal of Barbados. The Caribbean Court of Justice found a way of circumventing the saving laws clauses and holding that in the case of Barbados, at least, the mandatory death penalty was unconstitutional. I won't go into the legal technicalities of that, but I think that puts paid to the idea that the CCJ is a hanging court, and it also, I think, supports the idea that it will develop a distinctive Caribbean jurisprudence, particularly if we look at a second mandatory death penalty case, that of the Privy Council in Chandler and the State. And the Privy Council was well aware of the CCJ's decision in Nervais and R. Chandler and the State was an appeal from Trinidad and Tobago, in which the Privy Council upheld a law prescribing a mandatory death penalty. It felt that the saving clauses stood and there was no way of circumventing those. Okay, if I could just go to the final slide. Okay, so where do we go from here? I've looked at the countries that have yet to subscribe to the CCJ. Countries of the Eastern Caribbean, the islands of the Eastern Caribbean. In that case, if they wanted to subscribe to the CCJ, they would need to put it to voters in a referendum, and they would need a majority of voters to support it. And in Antigua, Grenada and St. Vincent, in fact, they would need a 2/3 majority to support replacing the Privy Council with the CCJ. And we know that in 2018, in Grenada and Antigua, it was put to the voters in a referendum, and not even 50% of the voters supported replacing the Privy Council with the CCJ. I don't think it's going to happen anytime soon in the Bahamas, because the Bahamas doesn't even subscribe to the CCJ's original jurisdiction, let alone its appellate jurisdiction. In Jamaica, they tried in 2005 to pass legislation to replace the Privy Council with the CCJ, and they tried to do it by an ordinary legislative majority. And we know that in the Privy Council, it was held that wasn't sufficient, and that they would have at the very least to pass a special legislative majority. And the Jamaica Labour Party actually argue that they would need a majority in a referendum. Trinidad and Tobago, no referendum needed. But I think the closest that Trinidad's come to replacing the Privy Council with the CCJ was the suggestion back in 2012 that it would use the CCJ only for criminal appeals, but for no other matters. So as it stands, I think it's going to be a while before any of the other countries in the region replace the Privy Council with the CCJ. I'm very sorry if I've overrun there.
No, that's excellent. Thank you very much, sir. You've clearly enlightened us, and particularly about the origins of the operations of both CCJ and the Privy Council. Thank you so much. Ladies and gentlemen, if you have questions for Dr. O'Brien, as is normally the case, we will take those questions and comments after all the presenters. So at this point, I'd like to bring on our second speaker, and that is Barrister Rowan Pennington Benton. He's also from the UK. He's practicing from 3 Harry Court Chambers in London and from Hassan's International Law Firm in Gibraltar. Welcome, sir. You have 15 minutes. Please unmute.
Right, thank you very much indeed. Can you hear me?
Yes, clearly. Thank you.
Excellent. Well, thank you very much for inviting me and for the introduction. Thank you, Dr. O'Brien, for that really excellent introduction to the topic. I myself, as a practitioner who specialises in Privy Council cases, usually feel the need to try and defend my practice and long live the Privy Council so that I won't be poor. But I'm going to try and resist that temptation today. And having been involved in this debate, which has been raging for quite some time in various different forums, I wanted really to move away from the sort of, here's the reasons why you might move to the CCJ, here are the reasons against, and it's a case of weighing them up. And just to say, to focus on three themes really, to test some of the underlying assumptions that we make about this debate, because there is a danger that it becomes, the debate becomes a bit sterile, and it stops actually the progress that the Caribbean Court of Justice could make in this area. And I'll explain why I say that in a moment. The three themes that I want to focus on to really test the contours of the debate are the question of autonomy, the question, secondly, of ownership and participation, and thirdly, the question of the issue of language. And these are interrelated themes. And really the first theme, autonomy, is something that continues from a debate I had at the Commonwealth Law Conference in the Bahamas. I think it was in September last year or the year before, I can't remember. But anyway, with Sir Dennis Byron, who of course was for a time president of the CCJ and sat on the decision in Nervais, which I think was deliberately set out as a decision of the CCJ, showing that it wasn't going to necessarily always follow decisions of the Privy Council. So I think it was deliberately set out in that way. And one of the things Sir Dennis said to me about the CCJ and the need, as he put it, for the people in the Caribbean to sign up to the CCJ was that it was an important part of their independence and their personal autonomy. And it did strike me that there was a tension between that and the fact that, as Dr. O'Brien has pointed out, there have been several referenda where people in these jurisdictions have been asked whether they wish to join the CCJ, and they have said no. And you've seen the remarks from the UNC senator at the beginning of the programme this evening. I suspect, I don't know because I've not done a straw poll, but I suspect if the people of Trinidad and Tobago are asked whether they'd like to join the CCJ, the answer would still be no, as presumably it was when they decided in their constitution that they would retain the services of the Privy Council. So I do think it has to be accepted, first, that there is a concern, and that it is a concern borne by the people who would use the services of the CCJ about throwing off, as it were, the Privy Council jurisdiction. But the point here in terms of autonomy is, look, if the people of the Caribbean states that have been listed by Dr. O'Brien don't want the services of the Privy Council, they could get rid of those services at any time. And it's important, but it's also okay to say, listen, we come from a small jurisdiction. Obviously, Trinidad is one of the larger jurisdictions, but many of the other Eastern Caribbean states are very small indeed. I work in Gibraltar for a good proportion of my time, and it's okay to say, I come from a small jurisdiction, and actually I appreciate having the services of a of 5 law lords or law ladies in a court based in London, not because they're independent in the sense of being impartial in a way that CCJ judges can't, but because they're independent from the issues. And I think that's an important distinction to make. It's not necessarily criticism. One criticism is sometimes made is that the CC judges may be influenced personally or in some sort of bias sense. But I think the real point that's being made is about independence from the issues. And it's okay to say that. It's not about submitting to a colonial jurisdiction. It's okay to say, look, we're a small jurisdiction and we choose to retain the services of the Privy Council if that is what you want to do. So I don't respectfully actually see it as completing a circle of independence or necessarily completing the circle of independence. And that comes on to the second related theme, which is ownership and participation. And of course, Trinidad and Tobago as a republic, Mauritius as a republic, have decided in their own constitutions to retain the services of the Privy Council. And when I speak to people, I know there are a lot of cases from Trinidad, and Trinidad is one of the most sort of prolific appellants to the Privy Council. It gives a huge proportion of the Privy Council work comes from Trinidad, because you guys are seriously litigious, let's be honest. But when I speak to people from Trinidad about these cases to the Privy Council, they talk about it's their court. They don't talk about, it's the Privy Council, it's not a foreign tribunal. I don't recognise that language. When people talk about Privy Council, in large part, they're talking about their court, their country's final appeal. And that's how we think about it in Gibraltar too. And Gibraltar is obviously a British overseas territory, so these issues don't cut so deep, but it's our court. So I think there is something to be said here about ownership of the Privy Council, and whether, of course, it's right. I mean, I saw an article in the Times the other week asking whether the Privy Council is a colonial relic. And of course, in a sense, it is. Of course, it is a colonial relic, because ultimately it is a board set up to advise Her Majesty as to how she should distribute and execute justice in her dominions. Fine. But almost every institution, in the United Kingdom at least, enjoys, if you look far back enough, those anti-democratic, anti-freedom credentials. The question really is, what role does the Privy Council adopt today? And I think the relationship between Trinidad and Tobago in particular, and Mauritius also, the Privy Council, demonstrates that actually it is possible for a state to take ownership of the Privy Council and make it its own, which does bring a different. I'm not saying that answers the debate, and I'm not saying it undermines any of Dr. O'Brien's arguments, on either side of the balance, but it informs the debate. Another thing that informs the debate is an assumption that the Privy Council and the CCJ each enjoy immutable, unchangeable characteristics. The Privy Council is this court in London that is manned by a bunch of, old white male British lawyers. But on the whole, of course, that's true. And on the whole, of course, it's also true at the moment, the CCJ is manned by some pretty serious jurists, almost exclusively from the Caribbean region. But those are not necessarily immutable characteristics. One of the things I suggested to Sir Dennis Byron that he was not very keen on, I should say, that the CCJ could do and the Privy Council could do is to actually exchange judges. Because the Privy Council will always exist. Don't forget, there's all the British overseas territories, and there's its Scottish jurisdiction. So the Privy Council will always exist as an international common law court of high repute, always, whether the countries listed by Dr. O'Brien appeal to it or not. So will always exist alongside the CCJ. So the only question really is whether some of those states move from the Privy Council to the CCJ. Why should the CCJ, as an international common law regional court, and the Privy Council in London as an international common law court, not engage in a process where judges sit on each other's panels? That will actually enhance the exchange of judicial knowledge, regional experiences. One of the things I regularly experience in the Privy Council, if I'm appearing on behalf of the government or on behalf of a respondent, and I want to try and get the Privy Council to dismiss the appeal, if I've got findings in my favour by the local courts, I just say, oh, don't get involved. Don't get involved. You don't understand, you know, all the local decisions are based on particular peculiarities of the cultural things that are going on in St Kitts and Nevis, and don't get involved. And it works. But if you have a judicial exchange, actually, it gets behind a lot of those problems because judges start to actually understand what goes on in the Caribbean, and the Caribbean judges get to understand a little bit more about how Privy Council judges make their decisions. And, you know, there could be a lot of the concerns referred to by Dr. O'Brien could actually be assuaged, I think, by taking that kind of more collaborative approach. It doesn't undermine the CCJ if a Privy Council judge sits on its panel any more than it undermines a Privy Council decision when judges from local jurisdictions sit on it, which they often do. So that's that. And then the final point, really relating to that, is about language and titles. Of course, we talk about the Judicial Committee of the Privy Council, but of course it could be much more palatable to people if it was referred to as, you know, an international common law court, the services of which jurisdictions in the Caribbean may or may not use, depending on what the people of those particular jurisdictions want. We've seen the difference a name can make in the United Kingdom when there was a move from the Judicial Committee of the House of Lords to the United Kingdom Supreme Court in 2009. There has been a sense, I think, of public ownership of the court. It is no longer a committee room of Parliament, but a self-standing United Kingdom Supreme Court. The Privy Council now sits in the same building as the United Kingdom Supreme Court. One just walks to the court next door to go to the UK Supreme Court, and the court next door to go to the Privy Council. But I wonder if a name change is something that could improve the standing of the Privy Council. Of course, it may be that that's not a desirable thing to do because the Privy Council and the United Kingdom generally supports the work of the CCJ and a move towards it. But the thing to bear in mind is that, as I say, the Privy Council will always continue to exist. So you'll always have countries in the Caribbean, Turks and Caicos, British Virgin Islands, and so on, that are using the Privy Council. So unless they too could move over to the CCJ, which at the moment I'm not sure they can. So yes, those are just my thoughts really, rather than jumping on the sort of, you know, all the reasons for and against, just to throw in a few ideas about actually, could these institutions change the way they operate in a way that would actually cure some of these problems? That was a bit rapid. Have I done my time?
You have just 2 minutes left.
Well, I've said what I need to say, I think. Just check what else I want to say. Well, there's only one small point that I think actually the Privy Council does now hear quite a lot of cases remotely. I think that was sped up really by COVID. So, I mean, that gets over perhaps some of the accessibility points, but I think the main points of principle are absolutely rightly raised by Dr. O'Brien. I just wonder, as I say, whether there are changes in the practices of these institutions that might help the CCJ move its position forward. I think that's my central point. 2 minutes.
Excellent. Thank you very, very much. You've been very insightful and provocative presentation, and I look forward to the questions that will come to you after.
Very good. Thank you.
Thank you so much. Let me introduce the third speaker, and this is Dr. I'm not too sure if I'm saying this correctly. Is it Dr. the Honorable Justice Anthony Gafoor, or is it His Honor Justice Anthony Gafoor?
It really doesn't matter. It's fine.
Thank you. So, ladies and gentlemen, Dr. Gafoor is from Trinidad. He's the chairman and chief judge of the Tax Appeal Court of Trinidad and Tobago, which is the Superior Court of Record. He's the holder of a PhD in International Relations. Welcome, Dr. Gafoor. Go ahead, please.
Thank you very much, Madam Moderator. And of course, it's a delight to be here and to share this platform with, of course, my other distinguished presenters. I'd also like to thank Dr. Kumar Mahabir and, of course, the other organizers for being, responsible for the kind invitation. So I'm going to go straight in and just upload my presentation. So what I propose to do in this brief presentation is to touch on some of these points, which I've highlighted here by way of summary, to examine the significance of the Indian diaspora and the Indo-Caribbean community in particular, looking also at the challenges and legal concerns faced by the community, and then, of course, perhaps more traditionally, to look at the significance of the Judicial Committee, what movement there has been towards the CCJ, some of which has already been touched on by the previous presenters, the UK perspective and the continuing concerns of the Indo-Caribbean community, and of course, even more traditionally, the arguments for and against to a limited extent and the way forward. Now, if I were to seek to contextualize matters, one recognizes that when we talk about the Indian diaspora, one is really speaking about a shared cultural heritage, which is now, of course, of global proportions. And, terms that perhaps would be familiar to a local or regional audience would be those of Jahaji Bai, the ship brotherhood, which was, of course, shared by the indentured laborers coming over on the ship, very much the same experience, albeit, just as harsh, faced by the slaves who were transported to this part of the world and elsewhere. And Dipo Abai, the Dipo brotherhood, which were also cementing factors, which in fact even stretched beyond caste, religion, and language, and created that globalized feeling of being part of the Indian diaspora. In more recent times, other commentators have focused specifically on the Caribbean, and pointing out that although those of Indo-Caribbean descent, and one would also, of course, include mixed descent as well, occupy a position of considerable power and influence. And some of the areas highlighted here are that many of them are some among the best artists, writers, spiritual leaders, political thinkers, doctors, lawyers, scientists, and sportspersons, and of course, many other walks of life, as well as being very much engaged in the promotion of religious festivities, many of which are celebrated by way of national holidays within the region. And then Dr. Mahabir himself pointed out that one of the challenges faced by a significant part of those of East Indian descent are the issues of the culture receiving less recognition by the media and governments than it deserves. He goes on to point out, and flag up questions of institutional racial discriminations against Indians in Trinidad and Guyana. But this in itself has had a positive spin-off in leading to increase in ethnic consciousness and the development and affirmation of an Indian cultural identity that is unique to the Caribbean. And that is, I think, a sentiment that many would share. So I want to flag up essentially some of the legal concerns that, this particular minority group have tended to face, primarily drawn, I would think, from their background. And those would include some of the issues mentioned here. The desire for constitutional protection of fundamental human rights. Again, I think everyone wishes to have that, but of course, if you're a minority group, it becomes even more critical. And then, of course, the fear of ethnic and racial discrimination. We heard earlier about an unfortunate incident that took place in Guyana, which again seems to be, or possibly maybe another instance of that. Freedom to engage in religious and cultural practices, having an equal opportunity for and access to gainful employment and business opportunities, protection of intellectual property and professional reputations, and what is of particular importance to these communities, protection of land rights, including matters concerning probate and inheritance, many of which have actually found their way to the Privy Council over the years. And in fact, if one looks even at the most recent selection of cases for this past year, there are a number of them which also raise this issue. Now, the key issue, as I see it, for minority groups such as those within the Indian diaspora, within the Commonwealth Caribbean, lies in the central question of whether to support a regional international court such as the CCJ, which is of some 17 years vintage, over the Judicial Committee of the Privy Council, which of course is of much longer duration, some 189 years since 1833, and of course, whose jurisprudence has impacted on many of the areas mentioned. And this is how I would propose to focus my presentation for today. Now, the Judicial Committee decides something like 30 to 50 cases. In fact, before the COVID lockdown and restrictions, they were averaging maybe just over 50 cases. And over the last couple of years, they're down to about 30. And in fact, if you look at the cases over the last couple of years, many of them, I would say, possibly as much as even half or just under half are from Trinidad and Tobago. But most of its work still arises from its role as the final court of appeal for many legal systems outside the UK, admittedly smaller independent or dependent states, which comprise the UK's former colonies and dominions, but also include Trinidad and Tobago and Jamaica, as well as other key commercial territories such as Bermuda, Cayman Islands, and Gibraltar, and the bailiwicks of Jersey and Guernsey and the Isle of Man, and all of which share the common characteristic being relatively small jurisdictions. Now, the Judicial Committee, though, has lost, if you like, if one sees it that way, most of its overseas jurisdictions, many of which were of much larger territorial expanse, and these would include countries such as Australia, Bangladesh, Canada, Hong Kong, India, which actually established its own final Supreme Court 2 years after independence, Zimbabwe, Malaysia, Singapore, and then most recently, in fact, 1 year before the CCJ was established formally, the New Zealand. And there was a lot of debate there as to whether or not to make that move from the New Zealanders. Now, what I've done here in this slide is to highlight those countries, particularly those that have a substantial East Indian percentage. And you'll see that, particularly Trinidad and Tobago, 38%, and Mauritius, just under 70% stand out. There are other small percentages in some of the other Commonwealth Caribbean countries, Grenada as much as 11%. I didn't work out the percentage of Jamaica, but again, it's about 21,000, and that is considered to be the largest minority group there. And then, of course, St. Kitts and Nevis, 1.5%, St. Lucia, 2.4%, and St. Vincent and Grenadines, 6%. And, there may well be very important reasons why smaller territories still find it necessary to hold on to the Privy Council. But what I propose to look at would be some of the case law, which may instill some level of confidence in deciding that perhaps what might be seen as a leap into the unknown might not be such a difficult leap after all. Of course, Dr. O'Brien already highlighted those jurisdictions that had acceded to the CCJ, and they are set out here in the chart, spaced within a relatively short time apart, but again, a significant 5-year gap between Barbados and Belize, and then another 5-year gap between Belize and the Commonwealth of Dominica. And since then, for the last 7 years, no one, it seems, has really, or no jurisdiction has really decided to take that leap of faith at present, although there have been noises and representations as to some countries being on the verge, etc., St. Lucia being one of those mentioned, but not really being concretized in terms of legislation. And here we see in this chart the East Indian percentage of the national population, and of course with the reflection of those that have accepted the CCJ or they continue to maintain its connections with the Judicial Committee. And again, among the larger groups of East Indians, Guyana 43.5%, moving over to the CCJ, having, as we heard, abolished appeals to the Privy Council as far back as 1970, and so therefore there was a lengthy gap before accepting CCJ, of course, once it was established, or final court outside of Guyana. Trinidad and Tobago still holding fast to the Judicial Committee. Suriname, which perhaps we haven't mentioned much, but it has again retained its own final court there, and Belize more recently, as well as St. Lucia, Jamaica, and Barbados. And these other countries have a much smaller percentage of East Indians and those of mixed descent in their population. So the key concerns, as I understand it, of the Indian diaspora regarding whether to embrace CCJ as the final appellate court, I sought to mention here. It is true that East Indians are still a minority group within the Caribbean region, with, of course, significant populations in Trinidad and Tobago, Guyana, and Suriname, which has a different legal tradition. And one can encapsulate this, to my mind, best by the well-known phrase of famous French philosopher Alexis de Tocqueville, talked about the tyranny of the majority, and the fact that the CCJ, albeit an indigenous institution, is still perceived as a court which may not treat minority groups fairly. Some of the cases I've mentioned here highlight, though, whether or not that is still, in fact, a valid assumption. So I've mentioned, albeit not directly related to the Eastern community, the Maya Alliance case, which talked about the protection of indigenous land rights, and then the whole suite of cases, which I believe Dr. Rampersad may be talking about in greater depth, after the election of 2020, all of which were strongly critical of the incumbent government having its base within the Afro-Guyanese community. And these are Zulfikar Mustafa, which pointed out the flawed process in appointing the Guyana Election Commission, Christopher Ram, Bharat Jagdev, and Charandas Prasad, all of which were heard together, which again questioned the issue of the motion of confidence in the government and deciding that the 33 out of 65 vote was actually valid. And then Irfan Ali, who is the current president of Guyana, brought a case which established that the CCJ did have a jurisdiction to set aside the decision of the Guyana Court of Appeal on whether the chief elections officer could properly invalidate votes cast based on perceived irregularities. Now, the UK perception, I think, is an important one, and the Judicial Committee, albeit a court that had been established since 1833, and of course bearing in mind that Indian indentureship started sometime thereafter, has itself expressed views that the region should accept its own final court, because, as they've said, regional judges are, or indeed may be better placed to determine cases within the region, as they may be more culturally sensitive thereto, or because the service provided at some cost of British taxpayers should no longer be supported. And further arguments have also focused on whether even a lower category of judge should hear matters coming from the Caribbean states and some of the other jurisdictions. I've merely highlighted here some quotes before and after the establishment of the CCJ. One, of course, stretching back to the 19th century by distinguished Lord Chancellor Lord Brougham, who pointed out even back in the 1830s the importance of and the challenge that a foreign tribunal such as the Privy Council may have in understanding the cultural nuances, the habits, as he says, of persons overseas, And then more recently, distinguished Lord Hoffman in Trinidad and Tobago pointing out the significance of embracing the CCJ. In particular, he said that my own view is that a court of your own is necessary if you're going to have the full benefit of what a final court can do to transform society in partnership with the other two branches of government, being, of course, the legislature and the executive. And finally, another distinguished advocate, Francis Jacobs, Privy Councillor himself, former advocate to the European Court, Justice as it was then known, talked about the fact of the CCJ being a Supreme Court of the highest caliber, and but also going on to point out that it was regrettable that political difficulties have obstructed acceptance of the appellate jurisdiction and the outdated jurisdiction of the Judicial Committee. So how has the CCJ come about? Well, we've heard a little bit about this already. In terms of the immediate history, there was a Gleaner article going back to 1901 calling for a regional final court, the establishment of a West Indian Court of Appeal, but of course, where its decisions were still subject to review by the Judicial Committee. The Federal Court, established under the Federation back in 1958, I think was also fairly well regarded. And then, of course, we also heard Dr. Bryan talk about the Time for Action report and the former Commonwealth Secretary General's Street at Ramphel, which called for the acceptance of the region of its own final court. And in fact, even more memorably, in giving the inaugural lecture of the Judicial Education Institute of the Judiciary of Trinidad and Tobago, using the phrase loitering on the doorsteps of colonialism. So in fact, when you look at the most recent statistics emanating from the CCJ's annual report, it pointed out the exponential growth in cases, albeit from those 4 jurisdictions, which they said amounted to 173.33% in new matters compared to the previous year, in which 15 matters were filed. So one can see the work of the court growing, albeit even from those 4 jurisdictions. So what are the key arguments in favor of the CCJ? Certainly savings of costs and time, certainly greater sensitivity to an ability to promote regional norms and values. I argue this in my thesis as being a central plank which may justify the CCJ's contribution to regional integration. And in fact, that is highlighted by the fairly recent case of Mirage and Petroleum Company of Trinidad, where the Privy Council relied and said it had to rely on the Trinidad and Tobago court to hold the justification for refusing to provide information under the Freedom of Information Act legislation required that court, meaning the local court, to have a role itself as a primary decision maker. And then Nerve, which we heard about a short time ago, also talked about the importance of whether or not savings clauses should be preserved, whether, of course, if they were to bring about an injustice. The case of McEwen is a case on point pertaining to transgender and of course cross-dressing, and there the CCJ held that although these savings law clauses of course had an important process of being protected in Caribbean constitutions, where that caused an injustice, then that was certainly questionable, and in fact they refused to apply it, or rather they disapplied it in that particular case. In contradistinction to this, the arguments against abolishing appeals to the Judicial Committee in terms of time and costs were somewhat, usefully illustrated by the 2017 case of Fishermen Friends of the Sea and Environmental Management Agency Authority, a case that was actually heard in Trinidad and Tobago virtually. As was mentioned, that hasn't been repeated, but potentially it can be. And then much more recently, in June last year, the quite important case of Smith and the Attorney General of Trinidad and Tobago, coming in the context of the airport's inquiry that has gone on for probably 2 decades or so. And there the Judicial Committee pointed out that it wasn't persuaded that there should be any particular deference shown to the decisions of the court below. Even more importantly, no doubt there may be cases where circumstances peculiar to the particular country from which the case comes, perhaps local customs, attitudes, or conditions are of direct significance, and are matters which the local courts are better placed, but this was not one such case. So, cultural assumptions, I think, are all well and good, but one has to understand whether or not that actually may apply in the particular case. And then, of course, in terms of the status of well-established courts, the Judicial Committee certainly fits that bill, as well as the challenges of changing those provisions, except with bipartisan support, or the possibility of legislation to bring in a referendum. So as I wrap up, the way forward then is it time to depart from the Westminster system of government? Well, I certainly think that greater education needs to be done about the entrenched provisions, as well as the greater awareness of the CCJ's judgments and rulings. Unless you see a clipping in the newspaper or something like that, many people are blissfully unaware of the great scholarship demonstrated by the court, as well as its independence and its commitment to social mores and values. But I do think that the CCJ itself should not be the one primarily promoting that. I think that there should be others, and if the governments of the region are truly committed to bringing about the reality of the Caribbean single market and economy, I think they have a responsibility to ensure that greater publicity is given to those judgments to enhance public awareness. And then, of course, consideration may have to be given to constitutional reform. This is something that is always going to elicit strong emotional concerns. But certainly greater protection for minority rights of the Indian diaspora, I think, are called for, as well as other minorities, as well as perhaps even now reviewing whether the agreement established in CCJ, which is now 2 decades old, is truly serving the purpose for which it was intended. I end by final thought from distinguished Queen's Counsel given at the Commonwealth Law Association conference last year, Mr. Richard Clayton, and this is what he had to say, that logic suggests that replacing the Privy Council with the Caribbean Court is not a question of whether, but when. Any move away from the Privy Council to the CCJ requires broad popular support. And I do want to emphasize that phrase, broad popular support, to give it legitimacy. He drew a comparison with the Brexit vote, which of course has caused all sorts of issues within the UK. The desire to take back control from the Privy Council CCJ is a sentiment expressed by many people. But as he says, it can only work if that development chimes with the national mood and aspirations. And so there I leave it, and thank you very much for your attention.
Thank you very much, sir, especially for contextualizing your presentation in reference to the Indian diaspora. So we've heard from Barrister Rowan, Dr. O'Brien, and from Dr. Ghaffur. Let's now move on to Attorney Ganesh Saru. You would have seen Senator Jayanti Lakshmi-Dayal listed as the next speaker. Unfortunately, she was unable to make it. And so we have Attorney Ganesh Saru, who was referred by her. He has been in practice for 7 years and recently appeared before the Privy Council. He is mentored by the illustrious Anand Ramlogan, Senior Counsel in Trinidad and Tobago. Welcome, Ganesh. Go ahead, please.
Good afternoon, a pleasant good afternoon to everyone. Is everyone hearing me loud and clear?
Loud and clear, yes.
I am not seeing my PowerPoint up.
Okay, Robert will have that for you in a second.
It is indeed an honor and privilege to be able to speak in a forum such as this. The issue of whether or not the CCJ should replace the Privy Council is not a new debate. This has been going on for quite some time, and most recently, a private motion was tendered in the Senate, which sought to debate whether or not the CCJ should be adopted as our final court of appeal. Now, we must be careful, next slide please. We must be careful to put this debate in context, because it is very easy to slip into an academic debate without having regard to what really obtains on the ground. And during that private motion, Senator Lakshmi-Dayal really made the point that before a debate like this could get off the ground, we must identify the problems that plague our justice system as it currently stands. Delays in our magistrate court, for instance, and our high court are legendary and incredible. And this is where the poor man really goes to seek justice. And this is where the bulk of justice is delivered. The high court, however, is slightly better, but there's no performance measurement standard to hold judges to. the Privy Council CCJ debate is one that should really take place when we have basic fundamentals of our local justice system right. Abolitionists do not appreciate the true reasons for our lack of confidence lies in our inability to manage and run an efficient and responsible system of justice in our local courts. And as Senator Lachmidial said in that private motion debate, sometimes it could be tantamount to debating what color we should paint the justice car when the engine itself is malfunctioning. So it is really a case where we must really get our priorities in order. Next slide, please. There's an argument that it is cheaper to access justice at the CCJ. This is not necessarily the case. The argument that it will be cheaper for the normal man to access justice if we replace the Privy Council with the CCJ is superficially attractive but lacks substance. And the empirical data really brings this out, because what it shows is that countries that have been using the CCJ, for countries, the CCJ annual report for 2021 shows that in Barbados referred 15 cases, Belize referred 4 cases, Dominica 3 cases, and Guyana 19 cases. The annual budget for the CCJ was approximately 60 million TT dollars, which really meant that Caribbean people spend that amount of money to decide merely 41 cases. The Privy Council, on the other hand, is free and paid for by the British government. And it goes back to fixing our problems first. Had this same amount of money been pumped into our local justice system, perhaps a greater deal of justice could have been more efficiently delivered to the people of Trinidad and Tobago. Also, the Privy Council, as you would now know, allows for virtual hearings so that lawyers and their clients can remain at home and participate just as effectively as if they were there. And I did have the honor and privilege to participate in one of these virtual hearings, and it was just as effective. Next slide, please. The next issue we can discuss is the issue of independence. The Privy Council is respected internationally. It is one of the strongest and most independent courts that has stood the test of time. The CCJ, on the other hand, is a fairly new court, and it will take some time to earn some international respect and confidence. In a recent article, one of my colleagues, Attorney Lee Mary, really queried on the opposite side of what I'm suggesting today, but whether or not any of us had gone to school with any of the Privy Council judges, ever played cricket with them in the road or lined with them in a fete. But this is exactly what people fear, that level of influence that is possible in a small island developing states. We are small islands, and the very possibility that a judge could socialize with somebody who they have to deliver justice to, you know, it can strike at the heart of an independent judiciary and the perception of whether or not fair justice is being delivered. And this is precisely one of the main reasons why people support the Privy Council. It delivers justice in a dispassionate and fair manner without any regard for position and status. So while we are talking about, removing ourselves from the Privy Council, I'll tell you that my experience with matters in the Privy Council is that it has been very efficient. Not only efficient, but transparent in the way the matters are conducted. Because before the matters even get off the ground, it is posted on the website, the Privy Council website, and there are periodic updates. And you can even access the video recording of the full hearing on the Privy Council website to consider the matter on your own. Next slide, please. This is another, the issue of self-determination is one of the main arguments that abolitionists favor, because they tend to promote that idea that there's a homogeneous Caribbean culture and identity, which is not necessarily true, because the culture in each Caribbean island is fundamentally different. The average non-Indian person outside of Trinidad and Tobago and Guyana knows as much about Indians and their culture as the British law lords do. And this is what gives them the independence from the issue and really gets into the black and white as to what the law is. Then on the other end, should these factors be even considered by the law lords in delivering justice, or should it simply be a matter of what the law is? In any event, the CCJ advertises for judges from throughout the Commonwealth. CCJ Judge Justice David Hayton, for example, is from the UK. In theory, the majority of CCJ judges can be from outside of the Caribbean. The idea that ditching the Privy Council for the CCJ would complete our independence does not necessarily make sense. And sometimes when we get into this debate, we find ourselves thinking, is this something that a law school student should be writing an essay on, as opposed to what really happens in reality? Because what people are more concerned with is fixing the rot from within our own justice system. And that is what we should focus on. And that is where I started off my presentation this afternoon. The other thing about this, all these arguments about sovereignty and the delivery of justice and access to justice, I want to put some context to it here. How many matters actually end up in the Privy Council? It's not a lot. It's not a lot from Trinidad and Tobago. And I will bring out that with the statistics in a bit. The area of our justice system, when you look at our courts as being neglected the most, is the poor man's court, the magistrate court, where the bulk of matters happen to be heard. So for example, next slide, please. All right, before we get on to that. So for example, in the last annual report from the judiciary that is available for the year of 2019 to 2020 on their website show that for the magistracy, approximately 80,000 matters were filed. In the High Court, approximately 12,000 matters were filed. But look at the sharp decline as we move forward. And in the Court of Appeal, approximately 500 matters were filed. This is less than 1% of our matters reaching to the apex court. And while we are trying to say that there are so many people, abolitionists trying to say that, well, so many people are being deprived of going to Privy Council to have their matters heard because it is too expensive or out of their reach to go to the Privy Council. How many matters actually reach there if only approximately 500 matters really get to our Court of Appeal here? The next issue I want to discuss is the important decisions for the Indian diaspora. And there has been quite a lot, but I've selected just a few to give mention to. The first one is the Central Broadcasting Services Limited, which is commonly referred to as the Mahasabha radio license case. That is a matter where two of our local courts did not recognize the violation of rights and unfair treatment against a body that represented a large portion of the Indian population. And they went to the Privy Council, and it's only at that level they were able to get justice, to get vindication for what they say were breach of their fundamental human rights. the other one of Firoza Ramjan and Ganga Prasad Kisun, when public servants first started to challenge appointments being made and the power of the prime minister to veto and so on, as being rooted in unfair treatment and discrimination, it is the Privy Council that they were able to access justice to. And when you familiarize yourself with these cases, you see there was a great deal of racial undertone about what happened in with respect to the vetoing of the appointment. The other one is the Trinity Cross case, the second case on the presentation there. The Sanatan Dharma Mahasabha Incorporated and others versus the Attorney General. Why are we so convinced that the law lords are so removed from our local circumstances that they do not understand our local circumstances? Again, that is not necessarily true, and that is fiction. The experience of, I think, anyone who really practices before the Privy Council and who understands the way they operate is this. When it comes, and I believe one of my predecessor presenters, Rowan, mentioned that when there's a question of fact, the judges do defer to the local circumstances that obtain in the country at the time. So to say that they are far removed from the cultural identity of the country is not necessarily true. And this is exactly what was done in the Trinity Cross judgment, which led to our highest award being replaced by the Order of Trinidad and Tobago. Next slide, please. So how do we move forward from here? For 189 years, the Judicial Committee has served as the country's final appellate court in civil and criminal matters, and any move to abolish it in favor of the Caribbean Court of Justice ought not to be decided by politicians. And Senator Lakshmi Dayal in the Senate read, and most recently, again, I believe it was 2 Saturdays ago, learned senior counsel Ramesh Lawrence Maraj really said that this is a matter that should go to referendum. Let the people decide. Let the people decide, because people will only have faith in a justice system when they know that they were part of it to some extent. And one article reported Mr. Maraja saying, as while the Privy Council may be replaced in the next 10 to 15 years, any government considering such a radical move should allow the people of the country to decide by way of referendum as citizens, and this is the important part, are the most important stakeholders in the administration of justice. We are the people that decision would affect. He said, to engender trust and confidence in the administration of justice, to engender trust and confidence, the administration of justice must be pure. There must be no doubt. Judges must be independent, fearless, and behave in a way both in public and private life for people to have respect for them. Next slide, please. So in conclusion, we really have to get things right at the lower level before we can engage, before we can focus our mind as to the CCJ Privy Council debate. You have to get things right on a basic level before you could take it to that level to move up. You have to creep before you walk. And we are not necessarily doing a good job at creeping at this stage because there are fundamental mishaps in our justice system as it currently stands. And a recent decision from the Privy Council would bear me out on that. Thank you.
Thank you very much, Attorney Saru. I think you've clearly articulated our Caribbean position in this. We really appreciate it, and please wait for some questions. I want to bring on our final speaker for today, and this is Dr. Indira Ramprasad. She is a lecturer in political science at the University of the West Indies, St. Augustine. She's the holder also of an LPC and an LLM from Staffordshire University in the UK and an LLB from the University of London. Welcome, Dr. Ramprasad. Go ahead, please.
Thank you very much. I hope I can now share my screen.
Try it.
So this is a correct one. It's the wrong one. Let me stop sharing that one.
That's still the wrong one.
One sec, please. Sorry.
Dr. Ramprasad, you want to start speaking to it? Because you have 15 minutes.
Yeah, just give me one sec. I don't know what is happening here. Okay, I think I have the right one. Really sorry about this.
That's all right.
All right. Okay, so we have our topic, and I have a little overview here. Can you all hear me?
Yes, clearly.
Okay, great. So these are some of the topics I'm going to talk to, overview. I had some slides on the history and evolution, but a lot of this has been said, so I don't want to repeat in the interest of time. But this idea of a regional court was mooted since 1901. Then we went on to the West Indies Court of Appeal Act, 1919. This issue was raised again in 1947. Then in 1958, there was a federal Supreme Court with the West Indian Federation and the British Caribbean Federation Act 1956. And so the court actually, the whole debate was going on even before independence, during independence, and after independence. The CCJ itself came into being in, the decision was taken in 2001. It was inaugurated in 2005. Now, it was inaugurated in 2005 with the CSME countries, all of them, 13 subscribing countries. But the Bahamas, by the way, is not a member of the CSME. It's a member of the Caribbean Community, CARICOM, but not a member of the CSME. Therefore, it would not subscribe to the CCJ and cannot. Suriname has its own peculiar Roman Dutch law, and therefore hesitant to subscribe because of that issue to the appellate court. Now, all the members are members of the original jurisdiction, and the original jurisdiction is governed by international law. So it's an international court. The CCJ has dual jurisdictions. It's an international court on the one hand, in its original jurisdiction, and it is part of our domestic court system as the CCJ for those countries that have subscribed to it. And the Privy Council is part of our domestic court system for those of us who have subscribed to the Privy Council. So it's part of the domestic system. We need to understand that. We have the whole hierarchy here: Petty Civil Court, Magistrate Court, High Court, Court of Appeal, and those subscribing to the CCJ, Barbados, Guyana, Belize, and Dominica. CCJ, Privy Council for the rest of us. Okay, so We have a number of regional courts, and I have some listed here. We have them scattered all over Asia, Africa, Latin America. We have the Caribbean Court, and we have two prominent international courts, the International Court of Justice and the International Criminal Court. The CCJ, like I said, is part of the international system of courts, and it is also part of a regional court. So it's two. Right, so let's go to the judges. Now, part of the problem with accession to the CCJ is this fear, suspicion, lack of trust, lack of confidence in the court. Who is the court? What is the court? To me, the court are the judges, and the court are its decisions, the judgments. That to me is fundamental to what the court is. So currently we have 7 judges. We have a St. Vincent, who is the president, 1 Jamaican, 2 Trinidadians, 1 Dominican, 1 Barbadian, and 1 Dutchman. The Dutchman, he's, they're all quite eminent jurists in their own respects. The St. Vincent the president served in the Court of Appeal in the Eastern Caribbean Court. The Jamaicans, an academic at Cave Hill, the professor. The 2 Trinidadians were in the Trinidad and Tobago Court of Appeal, that is Justice Jamada and Justice Maureen Reginath Lee. The Dominican and the Bajan, the Dominican was a lawyer who's moved up, and the Bajan also had a stint in the Barbados Court of Appeal. The Dutchman then been serving in St. Martin and other parts of the Dutch Caribbean Aruba before joining. Before we had Justice Hayton, who was also a leading academic at King's College, one of the leading practitioners in law of trust in the world, internationally, well published. Okay, so Dennis Byron, Kitian, he was also chair of the Rwandan Tribunal, also of international repute as a judge. Okay, so the judges, those are the judges. How are they appointed? This is something that is always being asked. They are appointed by an organization called the Regional Judicial and Legal Services Commission. And that went with the agreement establishing the Caribbean Court of Justice, which was formulated in 2001, passed through the CCJ Act in our domestic parliament in 2005. The heads of government of the CARICOM community, the agreement was passed by CARICOM. And so it's also governed by the revised Treaty of Chaguaramas. That's the original jurisdiction, has nothing to do with the appellate jurisdiction. So the president, the Regional and Judicial Legal Services Commission comprise the president of the court, whoever the current president is, 2 persons nominated by the Organization of the Commonwealth Caribbean Bar Association and the Organization of Eastern Caribbean States Bar Association, 1 chairman of the Judicial Services Commission of a contracting party, is selected in rotation in the English alphabetical order for a period of 3 years. Chairman of the Public Service Commission of a contracting party, selected in rotation in the reverse English alphabetical order for a period of 3 years. 2 persons from civil society nominated jointly by the Secretary General of the Community and the Director General of the OECS for a period of 3 years following consultation with regional non-government organizations. 2 distinguished jurists nominated jointly by the Deans of the Faculty of Law of the UE, the Deans of the Faculties of Law of any contracting parties, and Chairman of the Council of Legal Education, and 2 persons nominated jointly by the Bar or Law Associations of the contracting parties. All right, so while the president is appointed by CARICOM heads of government, such appointee must be recommended for appointment by the RJLSC. So who are they? Those in blue above are the CCJ judges, and those underneath are the Privy Council judges. Okay, so I brought this a little bit home because I have a little concern, and well, it's a big concern, because I think we're conflating issues. We're conflating issues to some extent. And I heard Dr. O'Brien about the issue under contestation here, is whether we can have trust and confidence in the judges. The CCJ is not the Court of Appeal, and it is not the High Court. The judges are appointed differently by different organizations. Let's get that fact very clear. We have major issues. I will be the first to admit. We have major issues with our local judiciary. We have major issues with some of the judgments of the High Court. We have major issues with the Chief Justice, with the Attorney General currently. We've had issues, Satnarayan Sharma, Vijay Narayan Singh, all those issues. Local issues with the High Court, Court of Appeal. The CCJ was never involved in those decisions, and we're making the assumption that some of those cases went to the Privy Council, and therefore the Indo-Trinidadian community got justice, and they would not have gotten had it gone to the CCJ. And I say we are making an assumption, and we have to be very, very careful about casting these kinds of aspersions. Now, at the Privy Council, so we saw the judges, they are all the lords of the Supreme Court in London, okay? They are sitting there, but they are part of our local judiciary. They're part of our local judiciary. But they also have concerns, and they have been expressing these concerns. Justice Gafoor, he pointed out some of it, you know. They're saying things like, such a final court must be aware of the society, have the necessary knowledge, legitimacy, and sensitivity to the politics. Lord Phillips is quoted as saying, he and his fellow senior justices spent hearing legal appeals from independent Commonwealth countries to the Privy Council in London. And he goes on to suggest that in an ideal world, Commonwealth countries would stop using the Privy Council and set up their own final court of appeal. And the Governor General of St. Kitts responded to that, and he's saying what he has said so politely, so diplomatically, to weaken Caribbean leaders from their slumber. And he suggested that if we had to pay to use the Privy Council, then it would have been a different question. Right. Now, a number of other countries have abolished the Privy Council. Some of the bigger ones: India in 1949, Canada in 1949, India when it got independence, immediately our motherland. South Africa in 1950, New Zealand in 2003, Australia, it was messy, you know, they began in 68, they ended up abolishing it in 1986. What are the concerns? What are the concerns? The concerns have been diversity in the bench. For a long time, there was no Indo-Trinidadian in the bench. Let's address the elephant in the room. Let us deal with these issues of gender, ethnicity, and class that plague our society. They do plague our society. So there was no Indo-Trinidadian in the bench for a long time. I was not happy with that. Many Indo-Trinidadians were not happy with that. Many Indo-Caribbean citizens were not happy about that. And they say justice must not just be served, it must be seen to be served. And the thinking is that if you have one, then you might get better justice. How rational is that? It's a different question. But so in July 2019, we got Justice Peter Jamada, very eminent jurist as well, Court of Appeal judge. We have no stigma attached to him. We have Justice Maureen Rajnath Lee, and the last name doesn't mean she's Indian, she's mixed. You know, so Dennis and I had this joke when she was placed there. I say, so Dennis, when we get an Indian in the bench, and so then I say, we have one. I say, oh, but she's a red woman. She's not an Indian. You know, so we did banter about it. But the point is that Justice Jamada came on the bench. But Justice Jamada, I don't know him to have any political connections. But if we want to make assumptions, what we'll say, he's the son of Vernon Jamada. Vernon Jamada was the second leader of the opposition of the DLP between 1967 and 1971 in Trinidad and Tobago. And that's a side, that's the UNC connection. The other side is he was a partner in the firm Jamada and Kangaloo, and we know the Kangaloos are well-established PNM family. And this is how ludicrous we can make these arguments and make these associations. Because so far I have read Justice Jamada's judgment and I can't find any politics in it or any bias in it against any Indian or any African or any white. And the question I have with this issue of gender as well, lone female boys club, it's been dubbed. And any female looking at the bench will say, well, one female. The same in the ICJ, yeah? The International Court of Justice, and the same, look here, same here in the Privy Council, one female, right? So we are biased there. We would want to say, if we're going to carry the argument, the question is, what do we look for? diversity is good. Justice must be seen to be done. Diversity is great. But you have 7 judges and you have 13 countries. And I don't know, I think they have been trying to get in those countries that subscribe to the appellate jurisdiction. Belize is not represented. Dominica, Barbados is. Guyana had one, Justice Bernard, also Justice Pollard, but no longer there is one. There are 2 Trinidadians. And there is 1 female, still Justice Maureen Rajanath, who's replacing our way Justice Bernard as a lone female in the bench. So, so the question is, how far are we carrying these arguments to claim bias and to claim lack of trust and confidence and to justify it? Now let's see what our Indo-Trinidadian leaders have been saying about the court. So the court actually came under the UNC when it was in power, 1995, 2001. In 1999, Basil Panley was the Prime Minister of Trinidad and Tobago, and he said that the government of TNT would provide a site to house the court, right? And there was a toss-up and, tussle as to where the seat should be, and Trinidad won under Basil Panley, and it's on Henry Street, Port of Spain, as we know. It's also an itinerant court in that it moves around the Caribbean if it has to hear some certain cases. Then in 2005, Kamla Prasad-Bissessar, she was an opposition MP. She expressed disdain for the CCJ. In March 2011, when she was Prime Minister, she boldly supported the Privy Council. She said there was no need to leave because there was nothing wrong with it, and if it ain't broke, why fix it? In April 2012, she opted to abolish the CCJ for criminal matters only because she needs civil matters to go to the Privy Council to instill investor confidence from the BRICS. The BRICS is, of course, those developing economies, Brazil, South Africa, and those countries. It was the year Trinidad and Tobago celebrated its 50th anniversary, and her Indo constituents were definitely silent with that comment coming from her. It couldn't go forward. Criminals appeal because the CARICOM leaders told her no, you're either subscribing to all or to none. Now, Sir Dennis told me he didn't have a problem with that. He said we have to start somewhere. He didn't have a problem with that. And how am I talking to Sir Dennis is because I was mentored to Justice Gafool for his PhD thesis. He was lucky to have as a supervisor the very eminent professor of law, Rosemary Bellam Twine, and maybe in the IR expert, she asked me to guide him. And we spent a lot of time, looking at some of these cases, interviewing judges, interviewing politicians, interviewing academics, and the cases, hundreds of cases, going through them. So this is, ongoing research which is going to be published soon. Keith Rowley, Prime Minister Keith Rowley, he agreed to support Kamla if her proposal was workable. And he said the PNM position is to go the whole way, a UNC position is go halfway, and there's a COP position which is to hold a referendum. He then described Prasad-Bissessar's proposal after saying that as an embarrassment. I'm not getting into the politics. I'll leave that for you all to assess. But the politicians themselves, even from the Indo-based party, have not been consistent. That is the point I'm trying to make, and have been modifying their positions over time. In 2012, she said that the time was right, as our democracy has grown in strength to strength, to take responsibility ourselves for the final adjudication of our disputes consonant with the pristine principles of justice and fair play, and say goodbye to the Privy Council as our final court of appeal. This is Kamla. She also stated that she would abolish the Privy Council as a final court for criminal matters, and this drew a protest from Prakash Ramadar, who was in the COP and part of the partnership, that we should go to referendum. Then in April 2014, she was speaking at UE. I was present, and this is what she said, and speaker after speaker were calling for the CCJ. Sina Triram was head of the Law Association at the time. Principal Sankat was there, Sir Dennis Byron. So it was, she called it the Trojan horse in the room. The elephant in the room. And she said, she repeated that accession, this is what she said, accession to the CCJ is inevitable. And she said it more than once. She noted that in Trinidad and Tobago's constitution, the UK-based Privy Council, as the country's highest appellate court, is one of the most entrenched provisions, which will not allow a simple majority to remove. Quite right. It requires 3/4 in the House of Representatives and 2/3 in the Senate. Accession to the CCJ is inevitable, not only for TNT, but for all of us in the Caribbean. That is inevitable. Everything in italics there is beside Bisassa's words. Question is always one of when. This is what she's asking. So this is a matter that ought to be put to a referendum at the appropriate time. So she's now coming around to the idea of the referendum. Accession to the CCJ is inevitable. All right. Now, last 2 Saturdays ago, 25th of July, 2022. And I think Mr. Sarup alluded to this brilliant presentation by attorney, senior counsel Ramesh Lawrence. And he's also calling for referendum, right? But he also sees it as inevitable. It may be 10 years, it may be 15 years, it may be 20 years. The Privy Council will ultimately be removed as the final court of appeal. He also, like Prakash Ramada, is strongly advocating referendum. He says there have been 8 attempts in the Caribbean and all but one, which was in Guyana, failed. And then we had Karen Nunez Teixeira, former Minister of Finance under the PNN, under the Manning regime, stating that she went to town on the cost. I heard Mr. Saru, it may be cost in the Caribbean, but we're talking here about the cost to the individual litigant. And she gave some figures and she said she has a case in front of the Privy Council. And the cost for her is exorbitant because you not only have to pay lawyers' fees, but lucky she got pro bono representation. She said that, but you also have to pay lawyers' accommodation. And everybody know airfare from the Caribbean to England, not cheap. And hotel accommodation in the UK is not cheap. Okay, so this debate, this whole entire debate on Privy Council and CCJ is driven, and this comes the class dynamic, is driven by educated, more or less elite, legal fraternity, the academics, including the judiciary and the politicians. I have a concern as to really whether the man in the street understands what is going on. Now they're hearing what is going on in media and whatnot and jumping on the bandwagon. And I am not sure the proper education is taking place as to really what the issues are and what the problems are, even in the referendum, voting ballot or whatever. I think right now, if I go outside my house and I poll 20 people and ask what you think about us delinking from the Privy Council and subscribing to the CCJ, they might say, CC who? Because they don't know what that is. And I know that for a fact because I teach this and my students did not know what it is, social science students, and don't talk for the rest of the students in the university. So these are second and third year students at the UWI. So the level of ignorance is very, very high. Now, we say the judges may be tainted. They know the politicians, they play cricket with them, they pitch marbles with them. But read the cases, read the comments. The politicians have been highly critical of the judgments when it didn't go in their way. A lot of the judgments didn't go, CCJ judgments did not go, and I'm talking about those countries that subscribe, didn't go in favor of the politicians, and they were cursing. They were seriously cursing. You know, this one called for Cabral Douglas, this is a private citizen who didn't win this case. He said, you know, don't subscribe to the CCJ. Dean Barrow, who is the brother of Denise Barrow, who is a CCJ judge now, he was furious over CCJ ruling when they said that Belize has to pay US $45 million to Belize Bank in a commercial case. Frondell Stewart, former Prime Minister of Barbados, he called them politicians in robes after he lost first Shanique Myrie and then Eddie Ventors. And you all know about Shanique Myrie. Eddie Ventors, this guy wasn't allowed. He's a St. Lucian citizen, lived in the Caribbean. He's a dean of the Faculty of Law of Cave, wasn't allowed to vote. Brought a case, won it. CCJ sat on a Sunday and they got his name in the electorals list, and Frondell Stewart didn't like that. In that election, Frondell Stewart got a good licking from Mia Motley. Whether that had anything to do with it, I don't know. But the point is that the politicians themselves have been criticizing the judgments when it didn't go their way. If it went their way, they kept quiet, happy. But if it didn't go their way, they have voted. So the point I'm trying to make is the judges are not making decisions to please politicians. And what we don't trust and what is the lack of confidence is the local judiciary. But that is not the local judiciary. It's a part of it, but it's a court, it's a separate court. And this is the point I keep trying to make, you know, and we have to be careful of treading that dangerous ground. We have a lot of problems, all kinds of ethnic problems in these countries, these islands. These are multicultural societies.
Dr. Ramanthal, would you mind wrapping up, please? We're running out of time.
I'm almost done. We have a lot of problems, but look at these cases, Guyana land cases. Indians, mostly Indians own land in the Caribbean, and they have been winning against the state and against other private individuals who may be Indians or who may be not. Then we had you know, some landmark judgments which are going to impact our jurisprudence positively. And then we had these political cases. And I have to tell you, I also had a lot of concerns about CCJ. I've been doing this research more than 10, 12 years now. And like the politicians, like Prasad says, I have been, you know, my mode has been changing. But after these cases, these Guyanese cases, after these cases, and I saw justice served, and I saw the pronouncement of the CCJ, and I read those judgments, not executive summary, full judgments, and I saw that they were committed to upholding good governance, democracy and sovereignty in the Caribbean, transparency and accountability. I was sold. I have to say this is what sold me. Thereafter, after the judgments, I called up people who I know in high positions, and I said, make a statement. Make a statement. And we saw politicians making statements, Mia Motley, Ralph Gonzalez, the Vice Chancellor of the University, making public statements against what the Granger government is doing, not wanting to step down. So to conclude, I just have some recommendations. There have been 100% compliance with the CCJ decisions, 100%. Even Granger had to concur in the end, had to agree in the end. The quality of a final court, are we going to use distance? I don't buy all this thing about loitering in the doorsteps of colonialism and sovereignty and imperialism and independence. And that is not the reason. The CCJ has adjudicated about 300 appellate cases, right? Many from Guyana, from Indo-Guyanese. They have adjudicated just 33 in the original. The irony is all 13 states are members of the original and only 4 are the appellate. And the cases have been going fast and furious. They have high-tech facilities, Mr. Sarup. I went and I did a tour of the court. I saw the technology with myself. I was able to view cases on Zoom. I was able to, the research justice Gafoor did, and with me guiding him, all the cases were online. We sit in the room, in the house, you know, he sat in his and I in mine, and we were looking at these cases. So this is not a court that's backward in any way. And the judgments, Nerve, for the LGBT community, savings law clauses, they're highly, highly progressive. Even Tomlinson, which they said they didn't have jurisdiction to do because he was claimed, human rights abuses because it wasn't a human rights court in the original jurisdiction. The archaic immigration acts of Belize and Trinidad, they brought it to the fore. So basically, we need to understand what this whole notion of diversity is. Trust and confidence. What is the basis of the lack of it, and who is it that we don't trust and who we have no confidence in? We need to educate our public, including our students, okay? Not to influence them in one way or the other, but for them to understand the facts, right? We need to read the CCJ cases, read the judgments. I have to tell you, I didn't agree with all, but I couldn't find one incidence of bias because they were all soundly argued. And the ratio, what we call a ratio, which is the reasoning, were without question, in my opinion. I believe that accession to the CCJ is inevitable. We're going to need a special majority. I don't know which opposition I'm going to support, right? In the House and 2/3 in the Senate. I also support referendum because I believe it is democratic. It is the democratic way to go, but we don't have that provision in our constitution. Those islands that did it, they have it. Jamaica has it, I believe, but they will have to amend the constitution. And Justice Gafoor spoke about constitutional reform. To do that, all you need is a simple majority. So So the debate is going on and on, around and around, but we need to get the facts clear. We need to understand what is happening, and we need to understand. I am now trying my best to understand the lack of trust and confidence, and what is it grounded and based on. I thank you very, very much.
Thank you, Dr. Ampersand. You've taken a very holistic view of the debate, and I'm anxious to hear what the other commentators would have to say. So thank you very much. I want to also thank our other presenters for all your time, your effort, your expertise, and availability. Thank you so much, Dr. O'Brien, Barrister Pennington Benton, Dr. Kapoor, Attorney Ganesh Saru. We have just about 10 minutes for questions. So I'll ask you all in the audience, please, if you do have a question, kindly indicate so by using the reaction button. Just raise your hand, please. And I want to start off by asking that question from Akash. Akash has asked whether any of the ICT platforms can be used by locals, and I assume others in the Caribbean, to access justice from the Privy Council in order to sort of avoid the airfare, hotel cost, etc., etc. So, Dr. O'Brien, would you want to respond to that, please? The use of technology for cases in the Privy Council. Yeah, Attorney Rowan, certainly, go ahead, please.
Yes, thank you very much. I can answer that. I mean, the routinely before lockdown, before the pandemic, the board was frequently encouraging parties by agreement to deal with cases remotely, and it's my understanding that if the parties agree, that can still happen now. So I think certainly that was regularly happening before lockdown, and then certainly during lockdown, all of the hearings were virtual. I've been back into the Privy Council, I think, twice since lockdown. They are starting to be more in person, but I think if the parties agree, that's no problem at all.
So how would they access the evidence then? The documents and so on would have to be faxed to them, or so they would.
Oh, sorry, you're talking about. Sorry, I thought you were talking about whether the parties to a piece of litigation could opt for having the thing dealt with remotely. They obviously can, and they will have access to the electronic bundle. But you're talking about members of the public, are you?
Sorry, Dr. Mahaber, would you mind muting your mic, please? Thank you. Rowan, go ahead, please.
Sorry, I was just trying to understand the question, because if the question is whether the parties to the litigation can conduct their cases remotely, the answer is yes, and they can obviously have access to the papers. Everything is filed before the Privy Council in an electronic bundle, and they zip about using the Adobe search function. But if your question, perhaps I misunderstood the point, if the question is whether members of the public can access, then all Privy Council cases are streamed online. But obviously, members of the public won't have access to the papers any more than you would if you walked into, the court in Port of Spain. You couldn't. I don't think you can access the papers. Maybe you can. I don't remember them being accessible. So, does that answer the question?
Yes, it does for me. Akash, I hope it answers the question.
Mr. Mendez, Douglas Mendez, who also appears before the Privy Council often, he says, as senior counsel, he says the agreement of the party. He said the current position is that you have to demonstrate exceptional reasons to have a remote hearing in the Privy Council.
Yes, we see that. Thank you very much. Is there a question from anyone else? Roseanne, go ahead, please. You need to unmute. Robin, can you please unmute Roseanne Kanhai?
Sorry, hang on.
Go ahead, Roseanne.
Okay, can you hear me, Darren?
Yes.
Am I unmuted? Okay.
Go ahead.
So I'm not sure I'm getting a good sense of whether attorneys themselves, whether there are more or less attorneys that are opposing the move to the CCJ rather than the Privy Council, whether there are more attorneys supporting the move to the Privy Council or away from the Privy Council to the Caribbean Court. And is it that, or does it matter, or does it influence, are they influenced by the fact that if an individual hires an attorney to go to the Privy Council, does that individual have to pay more in fees? In addition to personal expenses and fees, does the attorney get a better package if he's hired to go to the Privy Council, he or she, than if he or she is hired to go to the CCJ? Is that a matter? Is that a factor?
I would just say that you don't have a choice because Trinidad don't go to the CCJ, we go to the Privy Council. If you had the choice, I would prefer we have attorneys here in this audience that appear before the Privy Council. You have to bear the cost of the attorney's travel. This is what Tishera was saying because she had a case in front of the Privy Council, and you have to bear the cost of accommodation at the Privy Council. Okay, that's what I understand it to be. Maybe different attorneys might waive different fees. As to your first question on who supports Privy Council and who supports CCJ, we haven't had proper polling done on that amongst the attorneys, and that's the only way we can establish the figures, the statistics properly. All right, but we hear views, and like I said, it's driven mostly by an educated middle class. We hear views from the legal fraternity, from the judiciary, from the academics, from the politicians. But the polling amongst the population, proper polling, and I'm talking about national polling with proper sampling and things, has not really been done. Now, NAFTA has done some of it, a bit of it, but I don't think we've had proper polling on that as yet.
Good. Thank you, Dr. Rampersad. We have another question. This one is from Kasraj Maraj. It would be interesting to know what percentage of the cases from litigation-prone Trinidad to the Privy Council were successful. It will show whether the anti-CCJ sentiment is a valid one. So, Barrister Rowan, would you mind taking this?
Didn't answer the question about money.
Oh, she said there's no choice.
Yeah, but if there was
Sorry, I was just writing something on the chat to Douglas Mendes because I was concerned about his comment that the board said that they would only now hear remote hearings if there was exceptional reasons, because before lockdown, I know that they were encouraging parties to deal with the cases remotely. So if that is now the position, that's a shame, because that's really a retrograde step, in my opinion, because the whole point was that video hearings allowed people, got over that the cost consequences of coming to London. Anyway, so sorry, because I was distracted, I wasn't listening to the question. Sorry.
No, we appreciate that. So let me just ask the question again. It would be interesting to know what percentage of the cases from litigation-prone Trinidad to the Privy Council were successful. It will show whether the anti-CCJ sentiment is a valid one. Please comment.
Well, I'm just not in a position really to say how many cases from Trinidad, succeed. I mean, I can say that a lot of the cases that come before the board are from Trinidad.
Okay,
as I said earlier on, this is a fantastically vibrant jurisdiction with lots of interesting cases, but I just don't know how many succeed. Douglas may know, I don't know. Yes, he says he's done some research. He's done some research on that. This is Douglas Mendes, says he's done some research on the question of the rate of success some years ago and found that there was no difference between the rate of success on appeals from Trinidad and Tobago courts and appeals from UK courts.
All right. Okay. Thank you very much. Charian Rajkumar. Charian, go ahead, unmute, please. Charian.
Robin has to unmute her, I think.
Can you hear me? Hi, yes,
Hi,
thank you for
Charian.
meeting me. Hi, good afternoon, all. I just want to make a quick comment. I am also an attorney at law. I am all in favor of the complete abolition of the GCPC in hearing appeals. And of course, my position is that the Caribbean Court of Justice should be our final appellate jurisdiction. And I would also like to say that I am also not in favor of referendums being held. I think that the constitutional provision, the constitutionally provided way that has been set out in the Constitution should be followed. That's what I would like to say. I don't want to say too much more at this point because I know that there are more people waiting to add. Thanks.
Well, at the moment, I'm not seeing any further hands. So if you want to go ahead, Charian, please do.
So I can talk. Wow. Can I say something?
Mr. Ramracha? I'm sorry, I didn't see your hand up.
Yeah, can
you, yes, please do in 2 minutes, if you don't mind.
my question is that how much of this is motivated by politics and ethnic politics? We have to understand that we and sign on for independence with Black people, and they end up running the country for 50 years.
Okay, Mr. Ramracha, let's take
hands
Mr. Ramracha. Let us,
in
Mr. Ramracha, thank you. Thank you. Let us get an answer to your question, please. How much of this debate is motivated by politics or ethnicity? Dr. Ramprasad, would you like to respond?
I cannot figure out how much I can't. And I don't think that's expected. But I did say that the dynamics of gender, race, and class are significant factors guiding the discourse by an educated middle class in the region. I did say that. Okay. So we cannot escape that, unfortunately. You know, we cannot escape it because of the way our history has been shaped, our polity has been shaped. We cannot escape it. Whether the Privy Council judges understand that or not, I do not know. What I can say, and Mr. Sarup said it, and somewhat contradicting himself, they have sent back things to the Court of Appeal, this Basley Pandey and Ken Gordon case. They sent it back to the Court of Appeal to determine the damages, because they say that Court of Appeal will be better able to do that. And he mentioned some cases where they actually sent it back too, because they thought that they were not poised to do it. Now, listen, I have no problem with the Privy Council. I believe that judges do what they have to do in a professional manner. Unless I have proof otherwise, I will not make that pronouncement. I have no problems with the Privy Council, nor their judgments. I have no problem with that. They have served us long and they have served us well. There were cases that went in favor of the Indo community. There were cases that went against. Look at the last public health case, appeal, when it came to Caribbean. You know, Tishara raised the issue that if that had gone to the CCJ, maybe this whole thing, because the cremation issue was a big issue for the Indo-Trinidadian community when we had all this lockdown and thing. Would the Privy Council judges have understood that? I can't say. Would the CCJ judges have understood it better? Maybe, I don't know. But what I'm saying is that these debates have become integral to accession to the CCJ, the linking from the Privy Council. They have become integral aspects of it. And trying to rationalize everything is not easy. Thank you.
Thank you very much. We will take our final question from President Donald Ramuta. Go ahead, please, sir. You'll have to unmute. Robin, would you mind unmuting President Ramuta, please?
Are you hearing me now?
We're hearing you, yes. Go ahead, please.
Quickly, not a question. I just want to say I believe that the Privy Council has served well But I also think that the time has come for the Caribbean to move away from the Privy Council and join the Caribbean Court of Justice. The proof of the pudding is in the eating. The court has been in existence for many years already. And as the last presenter had said, there is absolutely no evidence that there is any prejudice as far as their judgments are concerned. You could criticize their judgment. I believe that judgments from the Privy Council also could be criticized. But I also believe that the Privy Council themselves have been saying to Caribbean countries that they should join the Caribbean Court of Justice. And in our case, in Guyana's case, from the experience that Guyana has, the whole issue, the whole question of the ethnic issue that has been raised here, I don't think it has been an issue at all. And I think we're raising issue that really doesn't exist. Because the court has not demonstrated in any way that they're taking any type of biased position in regard to the cases that go before them, that they deal with them on the merit and they deal with them on the basis of law. So I think after 60 years of Caribbean independence, it is time that we strengthen our own institution. If we are serious about Caribbean integration and Caribbean moving together, I think the time has come when we should try to strengthen the institutions of the Caribbean, and the Caribbean Court of Justice has proven so far to be one of the outstanding institutions of the Caribbean, which deserves to be strengthened. That is what I would like to say. Thank you for your attention.
Thank you very much for that contribution, sir. Ladies and gentlemen, I want to thank everyone for being here today. I want to specifically thank our eloquent speakers. I also want to say thank you very much to each of you all who would have asked questions and commented. I think we need to get some further responses from others who are in the audience. For instance, Kasraj, with regard to your question, let me just address that specifically. We will get in touch with Douglas Manzasi and make sure to get a response for you. Unfortunately, we don't have the numbers to give you at this point in time. So thank you all very much for being here today. That's as much time as we have for the program. We need to wrap up now. So I will just hand you over again to the chair. I'm Shalwa Mohammed. Assalamu alaikum. And now it's back over to Charlene Miraj.
Thank you so much, Shalima. Am I? Yes, I am unmuted. Thank you so much, Shalima. Thank you for moderating a very enlightening session, and thank you to the speakers. If I just want to, before I close, speak to that concept of independence that Dr. Rampersad said is not one of the reasons for us shifting over, because I recall Dr. O'Brien talking about it as circling and completing that circle of independence. But when I look at this concept of economic and social independence that we have, I question that. Our economic, if we look at the South-to-South trade that is happening in the Caribbean, it's probably a small proportion of the trade that we conduct with the international world and on the global level. When we look at our social construct, we have substituted our authentic heritage value system for very much imported social constructs. Our young people are basically going onto global platforms, and the connection with the domestic space isn't as much as we would like to believe. So is it one of independence that we should be talking about, or is it one of interdependence we should be speaking about and determining which institutions work best for us at which point in our lives? Dr. Rampersad also spoke to India, Canada, South Africa. The question of small island developing states has its own peculiarities as opposed to these larger territories. And it's something that we need to factor in. Again, I'm not choosing one side or the other, but we do it for the economic space. Why aren't we doing it for the judicial space as well? And the question of how connected we are. And while some may be comfortable at this time, given the body of cases that have gone through the CCJ, there are others who may need a longer time, and shouldn't we afford them that opportunity? Because feeling confident in that justice, I think is paramount, and not for us to call some of these things ludicrous. because each of us, you're asking us to park what some of us feel as institutionalized discrimination and to park it and put it aside and say, let us accept it. Maybe some of us need more time to be able to do that. And I think that should be afforded. But with that said, I think I am leaving personally on a much more enlightened note. I am pleased with all of the contributions. I have a better understanding of where we are as a region. And I would like to just formally close off our session today. I wish to thank everyone who participated today, especially our distinguished presenters. Thanks to the advisory and planning team led by Dr. Kumar Mahabir, as well as our IT manager behind the scene, Ravin Ramsing, who has been recording the program and will edit and upload it to our website and to YouTube, permanently for posterity. Thanks to Dr. Sita Shah Rowe for helping us to be vigilant in keeping out persons who may try to disrupt our program. This public meeting is being hosted by the Indo-Caribbean Cultural Center. Feel free to contact ICC to publish your books and reports. Also, like, share, and follow our Facebook page. Our topic next Sunday is Indians and Land Ownership in the Diaspora. May God bless you all, and Dhanyabad.